Let's now go live to The Hague and listen into what the judges are saying.
Chosen Judge Dikgang Ernest Moseneke and Israel, Judge Aharon Barak. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, paragraph 6 of the statute, that same provision applies to judges ad hoc. Before inviting Judge Moseneke and Judge Barak to make their solemn declarations, I shall first, in accordance with custom, say a few words about their careers and qualifications. Judge Dikgang Ernest Moseneke, of South African nationality, has had a distinguished career as a judge, law practitioner, and academic. After obtaining degrees in English, political science, and law from the University of South Africa, he practiced as an attorney and an advocate with the Pretoria Bar. In 2001, he was appointed a judge on the High Court in Pretoria, and a year later, he became a judge on the Constitutional Court of South Africa, where he was Deputy Chief Justice for more than a decade and Acting Chief Justice in 2013 and 2014. Judge Moseneke is also an honorary professor in the Department of Jurisprudence at the University of Pretoria and has served as a Chancellor of the Pretoria Technikon and the University of Witwatersrand in Johannesburg. Judge Moseneke has received numerous honorary doctorates and awards. I shall now say a few words about the career and qualifications of Judge Barak. Judge Aharon Barak, of Israeli nationality, has had an eminent career as a judge and law professor. He holds a PhD in law from the Hebrew University of Jerusalem and served as the Dean of the Faculty of Law of that university between 1974 and 1975. He was appointed to the Israeli Supreme Court in 1978 and served as its president from 1995 to 2006. Prior to joining the Supreme Court, Judge Barak served as the Attorney General of the State of Israel between 1975 and 1978. He has taught law in a number of law schools, including Yale University, the Hebrew University of Jerusalem, and the Reichman University in Herzliya, Israel. Judge Barak has also written extensively in law and has received numerous honorary degrees and awards. In accordance with the order of precedence fixed by Article 7, paragraph 3 of the Rules of Court, I shall first invite Judge Moseneke to make the solemn declaration prescribed by the statute, and I request all those present to rise. Judge Moseneke, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
I thank Judge Moseneke, and I now invite Judge Barak to make the solemn declaration prescribed by the statute. Judge Barak, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and consciously.
I thank you, Judge Barak. Please be seated. I take note of the solemn declarations made by Judge Ad hoc Moseneke and Judge Ad hoc Barak, and I declare them duly installed as judges ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. I shall now recall the principal steps of the procedure in the present case. On 29 December 2023, the government of South Africa filed in the registry of the court an application instituting proceedings against the State of Israel, alleging violations by the latter of its obligations under the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, South Africa invokes Article 36, paragraph 1 of the Statute of Court and Article 9 of the Genocide Convention. South Africa states that its applications concerns acts threatened, adopted, condoned, taken, and being taken by the government and military of Israel against the Palestinian people, a distinct national, racial, and ethnical group, in the wake of the attacks in Israel on 7 October 2023. South Africa contends that the acts and omissions by Israel of which it complains are genocidal in character because, I quote, they are intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnical group, that being the part of the Palestinian group in the Gaza Strip, end of quote. South Africa asserts that the relevant acts are attributable to Israel, which has failed to prevent genocide and is committing genocide, and which has also violated and continues to violate other fundamental obligations under the Genocide Convention. The application contains a request for the indication of provisional measures pursuant to Article 41 of the Statute of Court and Articles 73, 74, and 75 of the Rules of Court. According to South Africa, I quote, provisional measures are necessary in this case to protect against further severe and irreparable harm to the rights of the Palestinian people under the Genocide Convention, which continued to be violated with impunity. South Africa requests that the court indicate provisional measures to protect and preserve those rights, as well as its own rights under the Convention, and to prevent any aggravation or extension of the dispute pending the determination of the merits of the issues raised by the application, end of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of South Africa is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Madam President. I quote, 1. The State of Israel shall immediately suspend its military operations in and against Gaza. 2. The State of Israel shall ensure that any military or irregular armed units which may be directed, supported, or influenced by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation referred to point 1 above. 3. The Republic of South Africa and the State of Israel shall each, in accordance with their obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinian people, take all reasonable measures within their power to prevent genocide. 4. The State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Palestinian people as a group protected by the Convention on the Prevention and Punishment of the Crime of Genocide, desist from the commission of any and all acts within the scope of Article 2 of the Convention, in particular, a. Killing members of the group, b. Causing serious bodily or mental harm to the members of the group, c. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and d. Imposing measures intended to prevent births within the group. 5. The State of Israel shall, pursuant to point 4c above, in relation to Palestinians, desist from and take all measures within its power, including the rescinding of relevant orders, of restrictions and/or of prohibitions to prevent a. The expulsion and forced displacement from their homes, b. The deprivation of b1. Access to adequate food and water, b2. Access to humanitarian assistance, including access to adequate fuel, shelter, clothes, hygiene, and sanitation. B3, medical supplies and assistance. And C, the destruction of Palestinian life in Gaza. 6. The State of Israel shall, in relations to Palestinians, ensure that its military, as well as any irregular armed units or individuals which may be directed, supported, or otherwise influenced by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit any acts described in 4 and 5 above, or engage in direct and public incitement to commit genocide, conspiracy to commit genocide, attempt to commit genocide, or complicity in genocide. and insofar as they do engage therein, that steps are taken towards their punishment pursuant to Articles 1, 2, 3, and 4 of the Convention on the Prevention and Punishment of the Crime of Genocide. 7. The State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. To that end, the State of Israel shall not act to deny or otherwise to restrict access by fact-finding missions, international mandates and other bodies to Gaza to assist in ensuring the preservation and retention of said evidence. 8. The State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 week, as from the date of this order, and thereafter at such regular intervals as the court shall order, until a final decision on the case is rendered by the court. 9. The State of Israel shall refrain from any action and shall ensure that no action is taken which might aggravate or extend the dispute before the court or make it more difficult to resolve. End of quote.
I thank the Registrar. Immediately after the application containing the request for the indication of provisional measures was filed, the Deputy Registrar transmitted an original copy thereof to the Government of Israel. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix a date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for the indication of provisional measures, had been fixed for Thursday, 11 January 2024 at 10 a.m. I would now like to welcome the delegations of South Africa and Israel, and I note the presence before the court of the agents and counsel of both parties. This morning, the court will hear the single round of oral argument of South Africa, which has submitted the request for the indication of provisional measures. It will hear Israel tomorrow morning at 10 a.m. For purposes of this single round of oral argument, each party will have available to it a 3-hour sitting. In this first sitting, South Africa may, if required, avail itself of a short extension beyond 1 p.m. today, in view of the time taken up by these introductory remarks. Before I give the floor to the agent of South Africa, I wish to draw the party's attention to Practice Direction 11, which states as follows, I quote, "In oral proceedings on the request for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote. I now give the floor to the agent of South Africa, His Excellency, Mr. Vistumuzi Madonsela. You have the floor, Excellency.
Madam President, distinguished members of the court, it is an honor and a privilege for me to appear before you today on behalf of the Republic of South Africa. I wish to express my gratitude to the court for convening this hearing on the earliest possible date to entertain South Africa's request for the indication of provisional measures in this matter. In our application, South Africa has recognized the ongoing Nakba of the Palestinian people through Israel's colonization since 1948, which has systematically and forcibly dispossessed, displaced, and fragmented the Palestinian people, deliberately denying them their internationally recognized inalienable right to self-determination and their internationally recognized right of return as refugees to their towns and villages in what is now the State of Israel. We are also particularly mindful of Israel's institutionalized regime of discriminatory laws, policies and practices designed and maintained to establish domination, subjecting the Palestinian people to apartheid on both sides of the Green Line. Decades-long impunity for widespread and systematic human rights violations has emboldened Israel in its recurrence and intensification of international crimes in Palestine. At the outset, South Africa acknowledges that the genocidal acts and omissions by the State of Israel inevitably form part of a continuum of illegal acts perpetrated against the Palestinian people since 1948. The application places Israel's genocidal acts and omissions within the broader context of Israel's 75-year apartheid, 56-year occupation, and 16-year siege imposed on the Gaza Strip, a siege which itself has been described by the director of UNRWA Affairs in Gaza as a silent killer of people. As the Committee on the Elimination of Racial Discrimination warned on December 21st, hate speech and dehumanizing discourse targeted at Palestinians is raising severe concerns regarding Israel and other states' parties' obligation to prevent crimes against humanity and genocide in the Gaza Strip. This warning has been followed by a succession of warnings, including by 37 United Nations special rapporteurs, of the failure of the international system to mobilize to prevent genocide in Gaza. Today, we are joined in court by representatives of the Palestinian state, the Palestinians who work in the fields of human rights, including residents of Gaza who were in Gaza just a few days ago. They are some of the lucky ones who managed to get out of Gaza. Their future and the future of their fellow Palestinians who are still in Gaza depend on the decision this court will make on this matter. With the leave of the court, I now call upon His Excellency, Mr. Ronald Lamola, Minister of Justice of the Republic of South Africa, to make South Africa's substantive opening remarks.
I thank the agent of South Africa for his statement, and I now invite the Minister of Justice and Correctional Services for the Republic of South Africa, His Excellency Mr. Ronald Lamola, to take the floor. You have the floor, Excellency.
Thank you, Madam President and distinguished members of the court. It is an honor for me to stand here in front of you on behalf of the Republic of South Africa on this exceptional case. In extending our hands across the miles to the people of Palestine, we do so in full knowledge that we are part of a humanity that is at one. These were the words of our founding president, Nelson Mandela. This is the spirit in which South Africa acceded to the Convention on the Prevention and Punishment of Crime of Genocide in 1998. This is the spirit in which we approach this court as a contracting party to the Convention. This is a commitment we owe to the people of Palestine and Israelis alike. As previously mentioned, the violence and the destruction in Palestine and Israel did not begin on the 7th of October 2023. The Palestinians have experienced systematic oppression and violence for the last 76 years. On 6 October 2023, and every day since October the 7th, 2023. In the Gaza Strip, at least since 2004, Israel continues to exercise control over the airspace, territorial waters, land crossing, water, electricity, and civilian infrastructure, as well as over key government functions. Entry and exit by air and sea to Gaza is strictly prohibited, with Israel operating the only two crossing points. Given that continuing effective control by Israel and over the territory of Gaza, Israel is still considered by the international community to be under belligerent occupation by Israel. South Africa unequivocally condemned the targeting of civilians by Hamas and other Palestinians armed groups and the taking of hostages on the 7th of October 2023, and has again expressly recorded this condemnation, mostly recently in its note verbal to Israel on the 21st of December 2023. That said, no armed attack on a state territory, no matter how serious, even an attack involving atrocity crimes, can provide any justification for or defense to breaches to the Convention, whether as a matter of law or morality. Israel's response to the 7th of October 2023 attack has crossed this line and give rise to the breaches of the Convention. Faced with such evidence and our duty to do what we can do to prevent genocide, as contained in Article 1 of the Convention, the South African government initiated this case. South Africa welcomes the fact that Israel has engaged with the case in order to have the matter resolved by the court, after careful and objective consideration of the facts and submission put before it, as the parties to the convention have intended. This hearing is concerned with South Africa's request to the court for the indication of provisional measures and will necessarily have a narrow and particular focus. I invoke the words of Martin Luther King when he said, "The arch of the moral of the universe is long, always bending towards justice." South Africa's case will be presented by a team of 6 legal counsels, comprising of Dr. Adila Hasim, Mr. Tembeka Ngcukaitobi, Professor John Dugat, Ms. Blim Leckrone, Mr. Max du Preez, and Professor Vaughan Low. Dr. Adila Hasim, Senior Counsel, will provide an overview of the risk of genocidal acts in the perpetual vulnerability to acts of genocide. Mr. Tembeka Ngcukaitobi, Senior Counsel, will examine Israel's alleged genocidal intent. Professor John Dugat, Senior Counsel, will focus on the prima facie jurisdiction. Professor Max du Plessis, Senior Counsel, will discuss the various rights currently under threat. Blinny Crowell, King's Counsel, will present the argument of agency and potential irreparable harm. And Professor Vaughan Low, King's Counsel, will speak on the provisional measures. I now request, Madam President, the court to call on Dr. Hasim. I thank you.
His Excellency, Mr. Lamola, and I now invite Ms. Adila Hasim to address the court. You have the floor, madam.
Thank you. Madam President, distinguished members of the court, it is a privilege to appear on behalf of the Republic of South Africa in this case.
We've just been listening to those introductory arguments at the hearing there at the UN's top court in The Hague. Charges of genocide were brought by South Africa against Israel at the World Court. We're going to talk about that more now with Angela Diffley, who joins me on the set. Angela, let's talk a bit more about what we've just heard there from the South Africans in the context of today.
Yes, those first opening remarks before entering into the more legal aspect of this case really conveyed the background of South Africa's decision to take this. The South Africans' view of what Israel is doing, they talked of apartheid, of genocide, and you can see that they're very influenced by South Africa's own political story. The history of the State of Israel is a very different situation, the creation of the State of Israel, to that of South Africa. And very many historians, as well as obviously the State of Israel, would not concur with their interpretation of things. They talked about colonization. It is a complicated story, the State of Israel, with two very different histories, depending on who you listen to. I think it's important to say that. They also talked about Israel being under occupation, which a number of the international community do say that Gaza is under occupation. Israel points out that it was under occupation. There were settlers in there, but they pulled them out. And although it is under a security blockade or a blockade, depending on whether you think it is that necessary or not, the Israelis say the West Bank, there's an argument that is under occupation. Gaza, they would say, is not. But that's the sort of the political background to this. And you can see very firmly how South Africa looks at this, as any country is influenced by its own story, and how firmly it identifies with the Palestinian people and their plight in this story. Then they went on to the more legal arguments. And that first lawyer there talked about October the 7th, and the Hamas attacks, atrocious as they might have been. He said that is not a moral or a legal argument for the subsequent response by Israel. It should be said, Israel takes this court very seriously. Israel is a country which was set up after the Second World War. The idea that genocide would be associated with the state of Israel is not a comfortable thought. And so they're taking this very seriously. They will point out tomorrow that they are trying to abide by international law, that they give warnings, that they say Hamas uses citizens as human shields. That will be their argument. One of the very interesting arguments, which we will certainly hear from the South Africans today, is it is important to demonstrate intent to commit genocide. And the South Africans will point to a number of very inflammatory statements made by sometimes ministers in Israel about the Palestinians and about what might happen to the people of Gaza. And they will use that as intent to commit genocide. Israel says that those remarks were taken out of context and none of the people concerned were in the war cabinet, so it doesn't demonstrate anything. We'll hear that tomorrow. Netanyahu has put out a statement in English very clearly overnight saying Israel has no intention of displacing the Palestinian population outside Gaza. They have, of course, already been internally displaced, sometimes 2 or 3 times as they moved from the north to the south to avoid bombardment. The South Africans will point to the massive casualty rate, the restrictions to food, water, and medical supplies for ordinary Gazans. 2/3 of the population who have been under bombardment, 2/3 of those who have died are thought to be women and children. All of this is going to make it very, very difficult for the United States, for example, to continue to support Israel, even if further down the line, in a few years, a verdict is reached that this is not genocide. The idea that a plausible case is being considered puts Joe Biden in a difficult situation.
And the U.S. has already talked about this case, basically dismissing it as saying that, in my words, a waste of time, almost, you might say. When we look at this case and we look at this ruling on emergency measures, which is expected later this month, do we think that this could indeed happen, that the court will order Israel to stop the hostilities in Gaza?
Legal experts appear to be divided on that. It is a much lower bar, of course, than the decision about whether or not a genocide is being committed. The fact that they are considering it would allow them to say, in the meantime, stop military action in Gaza. They have done things like that in the past, and governments pursuing military action rarely heed this court. It can make decisions, but it has no power to enforce them. So whether or not it does, Israel will probably continue to conduct its operation in the way it would like to.
All right, Angela, thanks so much for that. So